Hi, welcome to the Minnesota Realtors e-video resource. My name is Chris Galler, and with me today is Susan Diori, our Senior Vice President of Risk Reduction and our internal legal counsel. She's an attorney, and today we're going to talk about agency law and the form that needs to be filled out when you're working with a client, either a buyer or a seller. Susan, you've been here a few years and worked on this form that's out right now, and you work with the Forms Committee.
Yes.
Can you give us an overview of when that form is supposed to be used?
Absolutely. Hopefully in residential transactions, most of our members are familiar with this form. It is a statutory form called the Agency Relationships and Real Estate Transactions. We need to have that form provided to that consumer at first substantive contact. First substantive contact has generally been interpreted to mean before you start talking about that confidential, motivational, financial information. So before we start talking about the price of the property, how much I can afford, things of that nature, we want to be providing this form to the consumer, and it's there to explain their agency relationship options.
Good. And the form is one page, and
one-
as you said, it's a statutory form. What does a statutory form mean compared to the other forms that the members use?
Right, so actually it's 2 pages long,
Okay.
but it's statutory forms means it's prescribed by in our Minnesota state statutes. And we have to substantially have the same language in this particular form that is already currently in statute.
And this form requires signatures from the consumer, correct?
That is correct. Well, it doesn't require that. Of course,
Okay.
we're asking for it because it is a confirmation, obviously, that they've received that disclosure. Certainly couldn't force a consumer to have to sign it, but certainly from a realtor perspective, you'd certainly want to make sure that you, if they did refuse to sign it, that you had some sort of acknowledgement that it was presented to them, that they've been provided a copy of that. Ideally would be to get their signature on it. It's just a disclosure only. It's not a representation contract.
And first substantive contact, there was a change in statute related to that disclosure, wasn't there?
There was a change in statute in the buyer representation contract.
There you go.
That might be what you're thinking of. In 2014, there was a modification to when you needed to enter into that buyer representation contract. Specifically, historically, we had language in the statute that said you had to have that buyer representation contract before we did any acts on behalf of the buyer, or before the purchase agreement. And in 2014, the legislature took away the before the purchase agreement. So in the buyer representation contract, you do have to have that before performing acts on behalf of your buyer.
Okay. So there are two similar languages as far as when you make the disclosure and when
Right.
you can enter into that contract.
Exactly. And same thing on your listing contract, right? You're going to need to have that prior to advertising that to the general public for sale. So all the way around, you're right. From an agency perspective, we want to be having those contracts in place, disclosure made first and foremost, and then those representation contracts intact before we start doing anything on behalf of those clients.
Perfect. And you've got an article in the December Minnesota Realtor magazine.
We do. I just put an article out on agency relationships, giving some good basic reminders and informational pieces on agency relationships.
Perfect. So, read the Minnesota Realtor magazine to get more information. We thank you for tuning in today. Have a great week.